Contentious probate is an up-and-coming area of law. 10 years ago, not many people knew what contentious probate was, but nowadays it is becoming much more well known, with factors such as the coronavirus pandemic amplifying the area. It is for this reason that I feel it is important for people to understand the area so as to protect their own interests as well as the interests of those around them. Historically, if someone left a will, then their estate would be distributed accordingly. Or in the alternative, if there was no will, then the estate would be distributed in line with the rules of intestacy. When parties were unhappy about this, they would likely be upset, but unlikely to do anything further. In present day, there are a number of ways in which you can challenge a will or your position in terms of inheritance. The first way in which you can bring a claim is when you have concerns as to the validity of a will. There are 5 grounds upon which you can challenge. The first ground of challenge is lacking mental capacity. You may have concerns as to whether the testator had the requisite mental capacity necessary to be able to execute a will at the time that it was signed. Mental capacity is often considered by reviewing the testator's medical records and considering whether there had been any long-term impairment or gradual decline towards the end of their life or at the time of execution. The second ground for challenging the validity of a will is lacking knowledge and approval. A testator must have a firm understanding of their will, approve the contents of the document, and understand the implications of its terms. Special care should be taken where a testator has certain vulnerabilities, such as hearing loss, visual impairment, low levels of literacy, or is frail or unwell in any other way. The third ground of challenge is undue influence. This is a notoriously difficult ground upon which to challenge the validity of a will, as the allegation is tantamount to fraud. The main issue being that the key witness to the allegation, the testator, will have died and so would not be able to provide evidence. And as meetings surrounding the execution of a will are private and confidential, it can be very difficult to gather evidence in support. It is the role of the person challenging the will to evidence that undue influence had been exerted over the testator and that this influenced them into either making or amending their will to include terms that were not the testator's true wishes. You must be able to prove that the testator acted against their own volition and that they were forced to make a will that they did not want to make. The next ground for challenging the validity of a will is fraud and forgery. These grounds are less common. If evidence can be provided to show that a will has been forged, it will be deemed invalid. Common steps in evidencing forgery include the instruction of a handwriting expert. Cases of fraud are even less common, but can include circumstances such as a third party impersonating the testator. Understandably, this happens a lot less frequently. The final ground for challenging the validity of a will is rectification. On occasion, a will may not accurately reflect the true intention and wishes of the testator. This can happen either by way of a misunderstanding between the drafting solicitor and the testator, or it can be by way of a clerical error, where something may have been typed up incorrectly. Disputes such as this are often approached by obtaining a copy of the drafting solicitor's file and reviewing the instruction of the testator. It is not always necessary nor appropriate to challenge the validity of a will in order to challenge the inheritance provision or lack thereof that you are due to receive. The Inheritance Act 1975 provides certain categories of people the ability to bring a claim against an estate if they believe that they have been left without reasonable financial provision. These categories of people include spouse or civil partners, children of the deceased, including adult children, any person that was treated like a child of the deceased, and any person being financially maintained by the deceased prior to their death. The important wording in such claims is reasonable financial provision. A court will not seek to allow a claimant to be put in a better financial position than is reasonable, no matter the value of the estate. Though the value of the estate will be a relevant factor, it does not create an unlimited value to a claim for reasonable financial provision. You do not have to be excluded from inheritance entirely in order to be able to bring a claim. These claims can be brought by any person who believes that they have been left without reasonable financial provision. The court will look at a claimant's financial position, their needs, and what they are due to receive, if anything, in their current position. If a claimant is financially stable, in good health, without debt, and can cater to their own financial needs, it is possible that a court will deem them to be lacking any need for financial provision. However, if a claimant demonstrates that they are financially unstable and that they are unable to meet their own financial requirements, a court will look to consider how an award from the estate could assist with this. To conclude, claims against estates are becoming much more commonplace, and it is becoming ever more prevalent for individuals to understand their rights and the options available to them. Here at Stephensons, I am the specialist contentious probate solicitor, and I work solely in this area. I conduct work for both claimants and defendants, practicing not only in will disputes and inheritance claims, but in all areas of contentious probate. If you feel that you are in need of advice, I would encourage you to get in touch and we will be happy to assist you.